Good evening, everyone, and welcome to the National Humanities Center Humanities in Class webinar series. Tonight's session is titled, Are You Free to Read, See, and Hear? Creating Consumer Rights Out of the First Amendment. And I'm very pleased that LeAnn Wheeler, Professor of History at Binghamton University, will be our lead speaker tonight. National Humanities Center was established in 1978 as a retreat center for university professionals who are advancing humanities scholarship. Every year we have a fellowship class of humanists. Those are historians and philosophers, classicists and literary scholars, musicologists and geographers. And they continue their work, their research, their writing to give us the knowledge that then becomes the basis of the classes and the curriculum that we teach. Our education department then is really designed to encourage and enhance the same kind of leadership in the classroom. We're excited to work with classrooms at all levels, from the K-12 level to the university level and community college level. And really, I think at the heart of what we attempt to do is offer content and resources and a strong connection with emerging scholarship to better understand these complex topics that we're facing in the world that we live in. My name is Andy Mink, and I'm the Vice President for Education. I oversee the department that creates those bridges. And at this point, if you can't hear my voice, or if at any point tonight, my voice, LeAnn's voice cuts in and out, or you lose audio for some reason, I'm going to encourage you to try to problem solve it on your end first. Oftentimes that connection is either in your Wi-Fi, or perhaps it's maybe a connection in your laptop or your earbuds. So take a minute and sort of troubleshoot to see that your audio is working correctly. And if we don't pop back in, I wish it weren't voodoo like this, but really the best solution is just to log out of the room and come right back in. And that usually seems to kickstart things pretty quickly and pretty easily. I also want to acknowledge and thank the rest of my education team at the center. Libby Taylor, who all of you know from the emails regarding our webinar series, is our education programs coordinator. And Mike Williams is our education programs manager. And the three of us are more than welcome to discuss the work that we do with you, or to take suggestions on how we can improve it. I'd encourage you to reach out to us via Twitter or by email, and we're happy to help you out with any kinds of issues, questions, or positive remarks that you might have. In terms of tonight's webinar, as many of you know, I see a lot of familiar names and faces in the room tonight. This is an audio-based and PowerPoint-associated webinar. There are a couple of reminders I'd like to offer you. Please make sure that your microphone is muted, because the best way for you to participate and to ask questions and to converse with each other is through the chat box. That chat box is located at the bottom of the Go to Training control panel, and you can use that in both a public and a private channel to register your thoughts, to respond to some of the open-ended questions that we might pose, to converse with each other, to offer your own thoughts and suggestions for the content that we're discussing tonight. I would also encourage you to make your own life a little bit easier with the bureaucracy that I'm sure you work in, to download our pre-approval form and go ahead and use that as a way to organize and submit the documentation of these sessions to your administration so you get the proper credit. Couple of announcements I'd like to make before we get started tonight. The first is we were a little overwhelmed and extremely pleased that so many of our webinars reached capacity at 200 participants almost immediately upon the registration being open and gone public. Many of our sessions, as you will find on our registration page, are sold out. So we've added 4 new sessions this fall and this spring, and I would encourage you to go and join any of those that you think might be relevant and valuable. That includes the first one in October with Patrick Balls on the unlikely marriage of mathematics and poetry, which is a really intriguing way to approach a truly interdisciplinary pedagogy. I'd also like to announce that we are strongly encouraging you to attend the sessions that you do register for. You know, when we send these out, or we open registration in August, and probably at the beginning of the school year, you go in and sort of sign up for all those that seem interesting, and then realize that something comes up, or you have to work a little bit later than you thought, or something's going on with your family. If that happens, we would like to encourage you to release your seat so that somebody from our waiting list can join. But I'd also like to incentivize this. If you attend 100% of the sessions that you register for in either semester, you'll be eligible for a special VIP appreciation session. The first one is titled The Barbaric Legacy of Sugar in America and leans heavily on the 1619 Project, which I'm sure many of you are familiar with from the New York Times. I apologize for the rustling. That's my cat in the background. And then in the spring, we'll be working with Carolyn Denard from Georgia State University on the life and writings of Toni Morrison. So whether it's one session or 10 sessions, please attend all the sessions that you register for. And if you do that, then we're going to send you a special hidden link that allows you to attend one of these two special webinars. We have numerous other resources that we would like to offer you in hopes that they're relevant and valuable for your classroom. These include instructional resources that you can find online, free and open and readily available in the form of lessons, primary source collections, essays, podcasts, and other kinds of media. We also offer a catalog of online courses, including a course titled Cut the Bull, How the Humanities Can Help Develop Critical Media Literacy, that's currently open. We're taking applications for that course that will be due by September 20th. And then finally, I'd like to announce a two-day face-to-face workshop on the use of geospatial technologies in the Global Studies classroom. Will be held at the National Humanities Center in October, and we would love to have your application for that if you are interested and able to join us in Durham. Finally, I'd like to thank our Teacher Advisory Council, not just this year, folks that were willing to join us and be a part of the National Humanities Center team, people like Nate Antiel from school here in Raleigh, North Carolina, but also previous years. The teachers that we've worked with in this capacity are very important voices in terms of making sure that we're relevant, making sure that the work we do is truly connected with the classroom. Folks like Camille Bernstein up there in Massachusetts. And we want to encourage you, if you're interested in working more closely with the National Humanities Center in the future, to keep an eye for our application process in the spring. So that's my short introduction, and really I'd like to spend as much time as we can tonight talking with LeAnn Wheeler, who again is a professor of history at Binghamton University, which is a part of the New York State University system. LeAnn is also the author, and if you find her work tonight and her conversation compelling, I'd encourage you to check out these two publications. One, How Sex Became a Civil Liberty, published in 2013, and the second one, Against Obscenity, in 2004. And LeAnn is going to lead a conversation tonight that on the surface, I think, and when you start to see the slides and maybe we get into this conversation, your immediate thought is going to be, how do you take this to your classroom? And I have a feeling that this is going to be a much more accessible set of constitutional questions and answers that than you might initially think. LeAnn, can you hear me in upstate New York?
I sure can. Hello, everyone.
Fantastic. Thank you for joining us. And before I turn the microphone over to you, I'd actually like to ask just a quick sort of off-the-cuff question, if you don't mind. And
Sure.
I often would get this from younger students in the classroom, and anytime talking about constitutional questions, and it was for them, I think, sometimes the difference between seeing amendments in the Constitution as an expression of what you can do or an expression of what you can't do. So which of those do you think applies to your talk tonight?
Wow. I feel like today that most people see the Bill of Rights as something that empowers them as individuals to claim
Yes.
rights and to give them permission to, to do things they want to do. So I think today we see them more as can do, although they were crafted as what the government can't do. So
Right.
They're definitely connected. But I do think that in a modern context, people are most likely to see them as empowering individual rights.
That's actually I love that word that you've used, empowering. And maybe as we work through tonight, we're going to be able to highlight and underscore those ways in which that empowerment is clear.
Yeah.
So again, I've handed you the mouse, and I'm going to keep an eye on the questions, although you're welcome to respond to folks directly as well. And we'd love to hear your conversation tonight.
Great, thank you. So I've got the mouse. That means your cat can't get to it, huh?
That's true.
I hear your cat in the background. Okay, welcome everyone. I'm really excited about this experience. I've never done a webinar, so this is a new thing for me, but I think it's super exciting. So we're going to talk tonight about the concept of this question, are you free to read, see, hear, and to look at the issue or the puzzle of how consumer rights have been created out of the First Amendment. So I want to first introduce myself in my own way. So this is me, my husband, and my 16-year-old son, Brady. My husband, Don Neiman, is also a history professor, and we teach together every other year because he's also in administration. He's provost here at Binghamton University. My 16-year-old son is 16. Enough said. Okay, so this is new challenge in parenting. Yours is 16?
He is, yes.
Wow, that could be a whole evening's conversation. Okay, this is a picture of us from our summer vacation. And then we have two dogs, Zuri and Sasha, pictured here. And if you hear barking in the background, it will be because they have something to say. Okay, so these are the covers of my two books. The first was Against Obscenity, A Reform in the Politics of Womanhood in America from 1873 to 1935. And the second, most recent, was How Sex Became a Civil Liberty. So my first two books dealt with issues of sexuality and how people have thought about, litigated, legislated issues of sexuality. My current book project is moving me in a very different direction. I'm writing a biography of the civil rights activist Anne Moody. You may have heard of her because she published a very popular memoir about her experience growing up as the daughter of sharecroppers in Mississippi in the 40s and 50s and becoming a civil rights activist in the 60s. Her memoir is titled Coming of Age in Mississippi and came out in 1968. And I got interested in this project because I've taught her memoir for 25 years. And my students and I always want to know what happened after 68. And now I am learning what happened after 68. So I'm hoping to have her biography written within the next 2 to 3 years. So that's my current project. So the big questions that have kind of motivated my first two books were, why do we think the way we do about issues related to sexuality? Why do we think the way we do? And why do we define pornography the way we do? Why do we think the way we do about the First Amendment? And why do we think the way we do about issues of rights? So I want to start by telling you kind of a teaching story of my own that helped to motivate my research on my second book. It was in 1997. I had just finished my PhD at the University of Minnesota, and I was invited to teach an honors seminar on any topic I wanted. So I chose the topic Rethinking Pornography and Hate Speech. And I wanted to start this class by getting a sense of where my students were coming from on issues of pornography and hate speech. So I gave them a survey to fill out anonymously, and it included the following questions. One was, how would you feel if your partner or spouse brought pornography into your home? And remember, this is 1997, before the internet. I was thinking in terms of VHS tapes and DVDs and magazines. Okay, and then I asked, how would you feel if your partner or spouse brought pornography into your home? And then how would you respond to that? And I was interested to see that one by one, nearly every female student in my class first assumed a heterosexual identity. So she talked about her partner or spouse as a male. And then she explained that while pornography made her personally uncomfortable, she would not demand that her partner remove it from her home for fear of violating his First Amendment rights. So I was curious why at the end of the 20th century, these students equated criticizing pornography and exercising control over their private space with advocating censorship that might even violate the First Amendment. I wondered why they blurred critical distinctions between private conduct and state action. I wondered why they thought this way. How and why did they conflate categories that seemed to me so separate? Personal opinions, private relationships, and civil liberties. So the work I did for my second book, How Sex Became a Civil Liberty, was all about answering those questions. And tonight what we're going to do is zero in on an episode that helped to shift American understandings of the First Amendment with the goal of answering the following larger questions. So here are the questions we're going to answer. And I tell you what, I'm not doing this all on my own, guys. This is like a joint enterprise. I'm not just going to lecture at you. We're going to talk. So, all right. So one of the questions we're going to look at is, or answer, is how did the First Amendment expand to include the rights of consumers? And by consumers, I mean people who consumed speech. So readers, listeners, viewers. How did the First Amendment expand to include those people in the 1960s? So I'm kind of making an implicit argument here that a major change took place in the 1960s. And then the next question is, what do the documents I provided you suggest about how and why our understanding of the U.S. Constitution, oh, there's a typo, has changed. Sorry about that.
Changed.
I know.
Yes.
So embarrassing. Okay. Okay, so we want to start by looking at the First Amendment itself. So I provided you a copy of the First Amendment. We're going to look at it together here. So let's start by reading it closely. So the First Amendment, which was adopted as part of the Constitution in 1791, states the following. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Okay, so what does the First Amendment prevent Congress from doing? And that's a question for you. And we want to focus here on the highlighted aspect of the First Amendment. Go ahead.
No, I just wanted to encourage everyone to type your answers into the chat box. This is not an idle and hypothetical question. This is goes directly to you. So
it's a real question.
Yeah, why don't you say the question one more time, and then folks will start to flex their fingers. And
what does the First Amendment prevent Congress from doing? What does the First Amendment say Congress shall not do?
Okay, we'll pause for a moment and let folks chime in. Again, the chat box is at the bottom of the Go to Training control panel.
Create laws that will prevent the people from saying what they want, limit what someone can write or say.
Thank you, Suzanne. Thank you, Natalie.
Yeah, thanks, guys. Prevent government from making certain laws, not to shorten the restriction. Very good. Okay, so the first responses I've gotten get right to the point, which is that the First Amendment was framed to prevent Congress from making laws that would get in the way of people saying what they wanted to say or publishing what they wanted to publish. So my point here is that the First Amendment was framed in terms of protecting people's right to say what they wanted and to publish what they wanted. So it was framed to protect the producers of speech, not consumers, but producers of speech. That was the original goal of the First Amendment. So now, as you can see, the First Amendment is much broader than that. It's not just about freedom of speech. It involves religion. It involves right to assemble. But I want to focus here on the part of the amendment that I've highlighted, which is the part that prevents Congress from passing laws that abridge the freedom of speech or of the press. And as you've quickly zeroed in on, that's all about the producers of speech. Okay, these cryptic phrases that make up the First Amendment have captivated scholars, lawyers, and judges since 1791 when they joined the U.S. Constitution through the Bill of Rights. What the framers of the amendment intended remains something of a mystery, actually, though most scholars agree that early modern speech theorists conceived of it as more than just the individual right of the one who produces speech. They also thought about it in more communitarian terms as a necessary component of democracy, one that requires listeners as well as speakers, readers as well as authors, citizens whose access to ideas and information would make their participation in the polity more meaningful and informed. So freedom of speech provided a tool for discovering truth, a marketplace for the exchange of ideas, in some ways a community bank account for the joint investment of speaker and audience, and a vehicle for sustaining democracy. But it did not, in anyone's estimation, in the 1790s or throughout the 19th century, the First Amendment did not contain an individual right to read, see, and hear. Okay, so why is it that courts today, we did that one. Why is it that courts today treat the First Amendment as if it protects the rights of consumers? And why is it that so many Americans today assume the First Amendment protects their right to read, listen to, or view, whatever they want. And that's kind of that's the question we're going to answer for the rest of our time together tonight. We're going to develop our answers to these questions by examining the documents in the kind of mini archive that I assembled for you. These documents came from a variety of different archives. So I gathered them from the University of Chicago Library, from Northwestern University Library, and from the Med Library at Princeton University. So these documents came from like larger archives, and I pulled them together to assemble kind of a mini archive for you.
And just a super quick question, LeAnn. These are clearly established and top shelf archives, but was there any reason you went to these three? Is there something particular about this work and these topics that are unique to these three, or is this just the three that you like to use?
Yeah, there's a reason I went to these. So first of all, there are big databases you can use to access archival materials. One's called WorldCat, and you can type in terms and topics you want to research, and WorldCat will come up with archives that contain archival materials related to it. But these three were particularly useful for this project because Mudd Library at Princeton University has the records of the American Civil Liberties Union, or the ACLU, the ACLU, and the ACLU was very kind of front and center in fighting many of these battles over how to interpret the First Amendment. Then I went to Northwestern and the University of Chicago because it was the Chicago-based ACLU chapter that took some of the first cases in the 1960s that helped to create a new interpretation of the First Amendment to make it a consumers-oriented amendment. So it's because of the cases that emerged in the 60s and also because of the ACLU that I ended up going to these particular archives.
Great, thank you.
Sure. So we're going to begin our exploration with Henry Miller. Henry Miller was an author who wrote a blockbuster sexcapade. That's my term for it. It was called Tropic of Cancer. Miller was an American author. He was born in Brooklyn, but his books were banned in the United States and in Britain because of their bawdy themes and their sexual frankness. So his book, Tropic of Cancer, there it is. Okay, that's the original version of the book. It was originally published in France in 1934 because Britain and the US wouldn't permit it to be published in English. So why was this book banned? Well, take a look at the cover. I mean, I think the cover probably tells us something about what's inside, but I've actually pulled an excerpt from you that I'm not going to read out loud, and I'm not going to recommend that you show this to your students because you'll probably get fired. Okay, so, but I'm going to let you read this for yourself. This is an excerpt from Henry Miller's Tropic of Cancer. It begins with a typo. Sorry about that, but I think you can figure it out. So I'm going to give you a couple of minutes to read this to yourselves. So when you finish reading that paragraph, feel free to type in why you think this book may have been banned in the US. It talks about stallions. The language is explicit. Yeah, a little bit. Graphic depictions of a woman's anatomy. Yep, and not for medical purposes, I don't think. Yikes. Yeah, and there's violence as well as very explicit and graphic sexual imagery described. So at the time that this book was published, first in the 1930s, there were very strict obscenity laws in most American cities and states. There was also a federal obscenity law, and these remained in effect into the 1960s. And so because of the obscenity laws that existed across the United States, this book was prevented from being published. The book, as you can see, expresses the perspective of a randy and undisciplined man who romped through 1930s Paris. Many readers saw absolutely no literary merit in it, and they called it smut for smut's sake. Others thought it was, however, an unparalleled masterpiece. So Tropic of Cancer was not published in the US until 1961. In 1961, Barney Rosset, a publisher in the US, procured it for his press, Grove Press. It was a press known for publishing controversial material that challenged the day's obscenity laws. Notice how bland the cover is in this 1961 edition. Okay, so now
it's almost a brown paper wrapper.
Yep. Okay, let's use the documents now, and we're going to use them in chronological order because I have to say that anytime I am dealing with a set of primary sources, I think the best thing you can do with primary sources is to line them up chronologically, because that helps them make sense in a way they don't when they're all out of order. So that's something I teach my students to do too. When I throw sources at them, first put them in chronological order. That way you'll know at least what order things happened in, and that can help you make sense of them. Okay, so to figure out what happened after Grove Press released Henry Miller's Tropic of Cancer in the United States, we're going to take a look at the second document, and I've numbered these with a number in the upper right-hand corner. So this is the second document. It's dated October 16th, 1961, and this one is a newspaper article, and it's titled 11 Police Officials Sued in Book Ban. Here's an excerpt from the document. It describes how one of the first cases around Tropic of Cancer developed. So I'm asking you now, who enforced a ban on Tropic of Cancer, and how did they enforce it? So who enforced the ban on Tropic of Cancer in Chicago, and how did they do it? And that's a real question. Hi, Camille. Yeah, a professor of speech was one of the people to protest the ban. But who enforced the ban?
The publishers, was it?
In a way, it's right there in the title of the article. 11 police officials were sued in the book ban. Yeah, so it was the police office. So local police in Chicago were going around to booksellers and telling them they couldn't sell the book, that it was illegal according to local obscenity laws to sell the book. So this was censorship that was happening in a very direct way, individual booksellers being confronted by police and threatened in some cases with arrest. Now, who challenged the ban? Who challenged what police were doing, and how and why did they challenge it? Okay, one was the ACLU. So we've got an organization here that's dedicated to defending civil liberties, that's resisting the police ban in Chicago on Tropic of Cancer. What about individuals in Chicago? What individuals? We've got an academic, sure. Franklin Heyman, a professor of speech at Northwestern. Who else? This is Isabel. Who's Isabel Condit? She's a housewife. Right, so we have a guy who's a professor. What is his basis for resisting the ban? Not clear yet. We've got a housewife who's resisting the ban. She's married to an ACLU member. We've got the ACLU resisting the ban. So the question is, on what basis are they resisting the ban on Tropic of Cancer? So let's continue. Now, Chicago was not alone. Tropic of Cancer was banned in lots of cities around the country, at least 57, and the impact on the sales of Tropic of Cancer went even deeper than the ban itself. Grove Press, the publisher that released Tropic of Cancer in the US, estimated that 75%, that's 3/4 of the nation's book dealers, either refused to stock the book or returned it after it was shipped because they were threatened by local police action. So in short, police confiscated the book, decency groups attacked the book, Many librarians refused to lend the book, booksellers returned it, but consumers continued to demand it in city after city. And so Franklin Heyman and Isabel Condit were positioning themselves as potential prospective consumers of Tropic of Cancer. They wanted to read the book, and they were protesting the ban because they were prevented from reading it because it was banned. And I think it's really important here to realize that in 1961, you couldn't get on Amazon and order it, okay? This is like you have to go to your local bookstore or your local bookseller to get the book, or your local library. You can't, there's no internet. And if you're teaching this material to students, it's really important to set the context of the 1960s for them, because they're gonna think, well, you can get any book you want, just like, you know, get online. Not an option. So if your local booksellers wouldn't stock a particular book, that often meant it was not available to you. The ACLU actually took the lead in challenging efforts to ban Tropic of Cancer, but they faced a major legal hurdle. Most local booksellers who were prevented by police from selling the book Tropic of Cancer didn't want to bring a lawsuit. So why might that be? Here's a picture of a Chicago bookseller, 1961, Crocs and Brentanos. Crocs and Brentanos said, we're not gonna bring a lawsuit. We're not gonna challenge this book. So why would bookstores refuse to challenge the ban on Tropic of Cancer? After all, they're losing money, right? They are business people, want to sell books, not right. So they're making money selling the books that they're allowed to sell. Locally owned to, right, so lawsuits are expensive to bring. Yeah, exactly, they want to keep good relationships with the local police. There are only certain people who want to read Miller's book, probably a lot of people who really don't want to see Miller's book in their local bookstore. Absolutely, so these are local businesses that really have to maintain a reputation with the local police as well as with their communities. And so many local booksellers really were not interested. Exactly, they're worried about boycotts as well. God, you guys are, this is awesome. Awesome, exactly. Okay, so the ACLU found that local booksellers didn't want to bring lawsuits, and that caused them some serious problems. One of the problems this caused for the ACLU and for Grove Press and the Tropic of Cancer is that local booksellers were the ones that had standing to sue. So now we're going to deal with some pretty sophisticated legal terminology, and the legal terminology we're going to deal with is the issue of standing. So they had standing to bring a lawsuit. You have to demonstrate that you have suffered a direct, concrete injury that can be redressed through litigation. So booksellers could easily say, I'm being hurt by this police ban on Tropic of Cancer because I can't sell the book and I'm losing money. However, booksellers, as we discussed, weren't eager to bring lawsuits because it cost them too much. And so the ACLU was looking for people to bring lawsuits, looking for people who had the standing to bring lawsuits. And booksellers were not helping them out with this problem. Now, one of the Chicago ACLU attorneys, Joel Spray Reagan, he was a feisty young lawyer fresh out of Yale Law School, and he was frustrated because booksellers and publishers were reluctant to challenge police censorship, so he was looking for another way to bring a lawsuit. So let's see how he did this by looking at letters that he wrote to a Harvard law professor and an ACLU official, and this is documents 3 and 4. So let's start with document 3. So what, according to Spray Reagan, was the standing problem in free speech litigation? Let's start with that question. What was the standing problem according to Spray Reagan? Let's go down about, let's see, start with the second sentence in his first paragraph. The standing problem in free speech litigation which I conduct for the Illinois ACLU, i.e., that the most important interest protected by the First Amendment is the public's right to have free access to ideas and publications rather than the publisher's or bookseller's right to make a profit, and therefore that this public interest should be recognized in litigation by allowing members of the public as well as the publisher and bookseller to sue to secure their access to ideas and publications. Okay, So that's a little convoluted, but what is he saying is his problem there when it comes to, what's the standing problem for Spray Reagan? Important to protect materials, not to profit, okay. So he realizes that booksellers, of course, have standing because they're going to lose profits by not being able to sue. But he says their profits are not the most important thing anyway. Okay, people have a right to read someone else's words even if they're obscene. What Spray Reagan is saying is that we really need to be interested in protecting the public's right to have access, not just the bookseller's right to make money. Exactly. Yep, people have a right to read. That his interest was in protecting the right to read, the right to consume, not just the right of booksellers to make a profit or to earn money. I mean, in a way, he came at this because he realized that booksellers were not going to protect their own rights. And so he needed to find a way around that. Okay, let's look now at what was the standing, we did that. How did Joel Spray Reagan hope to find his way around booksellers' reluctance to sue police? So take a look at document 4. And again, I think I've highlighted a crucial section for you there. Okay, how did Joel Spray Reagan hope to find his way around this standing problem or around booksellers' reluctance to sue local police? So if you go to the last paragraph on that first page of document 4, in the second paragraph, actually, he says, which is interesting, the problem of our standing to sue is formidable. He realizes he's got a real problem on his hands. So he says, I phrase the argument for standing roughly as follows. The most important social interest protected by the First Amendment is the right of the public to have free access to ideas and publications without governmental interference, rather than the right of the publisher to earn a profit. So how did Spray Reagan hope to get around the standing problem with regard to booksellers' reluctance to sue? What do you think he's going to do? Who does he want to use? Who does he want to bring a lawsuit against police in Chicago who are banning Tropic of Cancer? Okay, he's claiming that there's a violation of First Amendment rights. Whose First Amendment? The readers. Bingo, Kayla, awesome. So what Spray Reagan decided is that he's going to get some prospective readers to say, we aren't being allowed to read this book because the police are banning it. And we have standing to sue the Chicago police because our rights as prospective readers are being violated. Now, Spray Reagan, that's the excerpt we just dealt with, he realized that he was suggesting something that was pretty radical. In fact, he said, this is my next slide, it takes no genius to realize that the problem of our standing to sue is formidable, but we filed the case largely because we would like to begin to develop precedents establishing our standing, though recognizing that the first few times we may be bounced out of court unceremoniously. So Spray Reagan is trying to establish the standing rights of readers or prospective consumers. He knows that it might not work at first. He's hoping to establish a foundation and a precedent for doing this, but he thinks probably the first cases he brings are going to be thrown out of court and maybe he won't ever succeed at all. Okay, so let's take a look at the 5th document, which is a letter written by other ACLU attorneys. These ACLU attorneys are actually in Ohio and they're facing a very similar standing problem, the one Spray Reagan was trying to get around. And in this letter, an Ohio Civil Liberties Union chair tells a national ACLU official that, quote, there is little effective action that we can take unless some bookseller or publisher is willing to make of himself a test case. So we can see that other ACLU branches around the country are having a similar problem as Spray Reagan. They're having a hard time getting booksellers and publishers to agree to bring suits. As you all recognized quickly, local booksellers have a lot to lose by bringing a lawsuit. So Spray Reagan's efforts, could possibly help ACLU branches all over the country. In fact, Spray Reagan's strategy of bringing lawsuits in the name of consumers or prospective readers promised to expand the number of possible litigants exponentially to include individuals all over the country who had very little to lose. So let's look now at the sixth document. And that's a complaint filed by Spray Reagan and a diverse group of plaintiffs. So I want you now to look at who were the plaintiffs are numbered here. We've got 1, 2, 3, 4 key plaintiffs. So who were these plaintiffs and how did they identify themselves in the complaint? So who are the plaintiffs and how did they identify themselves? Common man, woman, U.S. citizen, yep, they identify themselves as citizens. What makes them common? Where do you see evidence that they're identifying as a common man or woman? What identifying characteristics do they include in this very short, they each have like a sentence or two that define housewife, yep, housewife with sons, housewife with a husband, housewife with kids. Yeah, so these people are identifying themselves as family members. We've got one who's a PR person. So we've got one who identifies himself by his job. We've got Franklin Heyman, who's got a PhD in speech. He's at Northwestern. So we've got a couple of men who have professions that they identify. They also identify themselves as married with a wife and children. And then we've got women who identify themselves as housewives with husbands and children. So here we got, yeah, as you point out, we've got the every woman, every man. These are kind of your ordinary people, maybe a little bit more educated than the common Joe or Judy. Why do you think Spray Reagan selected these particular individuals to bring the lawsuit? Married folks with 2.5 kids and the white picket fence, absolutely, yep. Middle America, the wholesome folks. Why do you think Spray Reagan chose them? Because Americans could relate to them. Hi, kitty cat. You want the mouse, don't you?
Sorry, that's Pete.
It's mine. No special interest. Okay, these are people who are not going to profit. They're not in it for profit. Maybe the jury could relate to them because they're educated and seemingly wholesome family people, relatable, good. Yeah. Okay, now let's look at, yeah, it counters the sexual nature of the literature. Oh, that's a great point. On the one hand, you see someone who's married as probably a sexual being, but on the other hand, you see them as sexual in a wholesome way, not in the way that the character in Tropic of Cancer was describing his exploits with Tanya, etc. So yeah, they're kind of like representing sexuality in the wholesome middle America kind of way. Okay, so now let's look at how they made their arguments. So first of all, they argued that they were residents in the suburb of Evanston, and they argued that they're literate and educated beyond the national averages and are capable of choosing their own literature, including whether or not they wish to read the said Tropic of Cancer, free from the kinds of unlawful interference alleged herein. So not only are they kind of middle of the road, normal, wholesome family types, but they're also educated and literate, and they should be allowed and able to choose their own reading material. They assert their rights as citizens of the United States, as readers of books, and they claim, this is a quote, fundamental rights of the citizens of any free and civilized society. These rights are incalculable and priceless to all free and civilized men, and these rights include the right to read whatever they want. Okay, so now let's look at the case that came out of this complaint. The case is named after the last name of the first plaintiff, and that was Franklin Heyman, so we'll call it Heyman, and it's named after the last name of one of the local police, and that would be Robert Morris. So we've got Heyman v. Morris is our case, and it goes to a lower court presided over by Judge Samuel Epstein, who's pictured here. Okay, let's see, where do I want to go here? Judge Epstein could have said, you know what, I'm not going to hear this case because these people have no standing. Consumers don't have any standing to sue under the First Amendment. They never have had. There's no precedent for that. This case is illegitimate. And Spray-Reagan was afraid that's exactly what he would do. So the first victory that Spray-Reagan and the ACLU experienced was that Samuel Epstein said, I will hear the case. This is a legitimate case. The litigants have standing. Let's go through with it. So he accepted the case, and that was a major, major victory. Okay, so Epstein did recognize prospective readers as protected by the First Amendment potentially, and Spray-Reagan and the ACLU became cautiously hopeful, but still realized all kinds of things could go wrong. Epstein released his opinion on February 21st, 1962, and it was, in fact, a game changer. I provided you with a copy of the opinion, and that would be document number 7. We're going to focus on the parts of it that really began to transform the First Amendment. To be honest, Epstein began to transform the First Amendment just by accepting the case and by accepting that the plaintiffs had standing to sue. But the opening sentence of his opinion kind of just assumed that these people should have standing to sue, which is interesting. It just treated that as like, of course. He says, plaintiffs as individual prospective purchasers of the book known as Tropic of Cancer by Henry Miller, and the publishers and authors of this book as interveners seek to enjoin the police commissioners of the city of Chicago. So he just kind of starts the opinion as if this is not controversial, when in fact it was. So he kind of makes it seem not controversial by treating it as if it wasn't controversial. He went on to point out that he could have rested his opinion on very narrow ground. He could have decided, for example, that the Chicago police were exercising censorship by prior restraint. Prior restraint was a form of censorship that was a no-no in settled law. You can't prevent someone from reading something before it's published, before it's made available. Prior restraint is a form of censorship that violates the First Amendment. But he said, you know what? I'm not going to make my decision on that narrow point. He also could have decided against the Chicago police by simply saying, Tropic of Cancer isn't really obscene. It doesn't meet the standards of obscenity that the U.S. Supreme Court has set forth in recent cases. But Epstein didn't do that. He didn't say it's not obscene. He didn't say that this is prior restraint. Instead, he said that consumers, prospective readers, have rights, and that Chicago police were violating those rights. So Epstein embraced Joel Spray-Reagan's claim that the First Amendment protects consumers as well as producers of speech, invoking a heretofore completely unrecognized freedom to read and touting the inherent constitutional rights and privileges of the reading public. So now the question is, what difference did this make? What difference did Spray-Reagan's novel strategy make? What difference did his victory in Epstein's court make? Because today, in fact, you'll be hard-pressed to find anybody who's ever heard of this case. I mean, it's been all but forgotten. But in its day, in 1962, Epstein's opinion received a lot of attention. It was covered extensively in the national press. It was widely declared a landmark in First Amendment jurisprudence. Oh, there's the excerpt. Sorry about that. Should have advanced her. Maybe I should give the mouse to your cat. It was covered extensively in the national press, and it was also identified as the first English or American case in which the right of readers to sue to challenge censorship has been upheld. If you look at document number 8, you'll see that organizations started changing their strategies in response to Epstein's decision. So, for example, this organization, the American Book Publishers Council, it had a bulletin that it published every month called the Censorship Bulletin, and it renamed its bulletin the Freedom to Read Bulletin after the 1962 Epstein decision. It realized that freedom to read was now the phrase that was going to be popular and get attention much more so than the issue of censorship itself. Like Spray Reagan and other ACLU attorneys, the American Book Publishers Council realized that if prospective readers took censorship personally and stepped up to establish and defend their rights, book publishers and booksellers would no longer need to consider incurring the expenses and risks of litigation. So what people like in the American Book Publishers Council and the ACLU and other organizations and presses realize is that if individual prospective readers think censorship is about their own particular rights, they're going to take it personally and they're going to mobilize to defend those rights. Oh, that's a good point, Teresa. 62, also the year that school prayer was deemed illegal. What do you make of that? Like, do you see some meaning in the timing of organized school prayers being deemed illegitimate and the consumer's right to read being inscribed in the Constitution? That's a good question. That's a dissertation right there, actually. Okay, also Barney Rosset, who was the publisher of the American edition of Tropic of Cancer, he worked really hard to draw more attention to Epstein's decision and to its consumer orientation by recruiting 200 prominent authors and publishers to endorse Epstein's decision in a statement in support of the freedom to read. This is a picture of the front of his Evergreen Review, which is a periodical that he published, prominently featuring Epstein's decision. More lawsuits were filed around the country on behalf of readers as plaintiffs in courts from Chicago, Illinois to South Bend, Indiana to Los Angeles, California, Montgomery County, Maryland. And in fact, even when the ACLU represented booksellers or publishers in court, it couched its role as defending the right of a free people to choose their own reading matter. So even when the ACLU was defending publishers and presses and authors and speakers, it also couched its defense of them as also a defense of the right of a free people to choose their own reading matter. Now, all these lower court cases were going on all over the country, and the Supreme Court brought an end to all of this lower court activity 3 years later in 1964 in a case titled Grove Press, which is the press that published Tropic of Cancer, Grove Press v. Gerstein. It was a case that made its way up from Florida, and it was decided in favor of Grove Press with no written opinion. So the Supreme Court decided the case in favor of the press and did not release a written opinion to explain its decision. Sometimes the Supreme Court does that. Super frustrating because you don't know why the court reached the decision it reached. But in fact, the Supreme Court came up with words that I think you could see as defending its position in this case the next year. It was an opinion that was written by Justice William J. Brennan, who said, and this is a quote, "It would be a barren marketplace of ideas that had only sellers and no buyers." So in 66, in Lamont v. Postmaster General, Brennan was arguing that basically we need to see the First Amendment as an amendment that's protecting buyers or consumers as much as sellers or producers of speech. So by the middle of the 1960s, the concept of consumer rights had moved to the center of the Supreme Court's First Amendment jurisprudence. Did so very quickly. How common is it for the Supreme Court to not release an opinion? That's a really good question, and I don't actually know. I just know it does it sometimes, and I don't know if that's changed over time, if it does it less now or more now. I couldn't tell you. It's a good question though. Google it. Okay. The other thing that this shift in First Amendment jurisprudence did is it inspired people to form new organizations. So if you look at document number 11, okay, document number 11 opens with a memo from Alan Reitman, who's an official in the ACLU, to LeAnn Goldman, another person in the ACLU, and this memo was sent in 1964. So take a look at this memo, and I assume you've read the attached document that explains what this organization was doing. But who founded the New Jersey Committee for the Right to Read? What kind of people founded? Let's see. Could the Supreme Court ruling cover not being forced to read consume specific material? You know, and maybe that is the connection to the school prayer issue, that the Supreme Court was being consistent in saying that consumers shouldn't be forced to consume, say, a prayer in a public school any more than they should be prevented from consuming what they want to consume in the public sphere. Focus on civil rights. You know, what's interesting is that however important civil rights was in the 60s, and it was, civil rights jurisprudence was blossoming alongside an expansion of the First Amendment. And those are also, you can find places where those intersect, where civil rights activists are claiming that their First Amendment rights should protect their right to resist. So those two come together too, and so that's, you know, neither overshadow the other. They kind of work together in many ways. Okay, so back to the New Jersey Committee for the Right to Read. So who founded this organization? Like, just in general, what kind of people founded it, and when and why? That is not a hypothetical question.
Mm-hmm. I mean, let's ask it one more time. And
yeah, so who founded this organization, the New Jersey Committee for the Right to Read? What kind of people founded it? When did they create it, and why? What were they worried about?
unfortunately, my Council of Churches, Teresa guesses.
Council of Churches. They may have been involved. Who was the initial founder? Let's see, let's look at, if you look at the second page, a chance remark by a Caldwell, New Jersey storekeeper in 1963 touched off a housewife's personal crusade against censorship. The housewife wanted a copy of James Baldwin's Another Country. Here's another place where freedom of speech comes together with civil rights. James Baldwin was a major African-American author who was very critical of dominant American race relations and a major supporter of the civil rights movement, and much of his literature was banned. And so here's an example of a housewife who wanted a copy of James Baldwin's Another Country and was finding it difficult to get because of local censorship. So here's an example of a housewife, much like the housewives who brought the Hayman case earlier, who's actually forming a grassroots organization to defend the right of people like herself to read what they want and to have access to the literature they want. And I think the timing's crucial. This is 63, 64. They're founding this organization to defend readers' rights right after Judge Epstein declared the reader's right under the First Amendment, just a couple of years after Spray Reagan brought his case claiming readers standing to sue and and claiming that readers have rights under the First Amendment. So one thing these individuals who formed this organization were concerned about was about police censorship, like what was going on in Chicago, but they're also concerned about censorship that they see being imposed by other organizations, like decency organizations. Citizens for Decent Literature was an organization that was trying to get local bookstores and booksellers not to stock particular titles. And so what the New Jersey Committee for the Right to Read claimed, and what the ACLU claimed, is that these decency organizations are opposing censorship every bit as effective as the Chicago police. So they turned this right to read into a right that they defended not only against government and municipal officials like police, but also a right they defended against other citizens, other citizen groups, other mobilized citizens who were trying to prevent booksellers from stocking books like Tropic of Cancer. So one thing this new right to read under the First Amendment did was it kind of pitted mobilized right to readers against mobilized decency defenders. Have to put the kids to bed, so ducking out. All right, good night, Camille. Good night, kids.
LeAnn, one unfortunate role as the moderator that I have is to remind us of the time. We have about a half an hour left.
Yep, we are going to get there. I think the pacing is going to work perfectly.
Good.
Okay, so one thing that this right to read under the First Amendment did is it created a concept of censorship that was not just, censorship was no longer just something that was imposed by government, by police, by municipal authorities. It was also something that could be exercised by other mobilized citizens. So it really expanded the idea of whose rights could be violated, and expanded the idea of what might constitute censorship. No longer is it just government officials who can exercise censorship, it's also other mobilized citizens who can exercise censorship. Okay, the ACLU, let's see, let's look at document number 12. And here's another document. This is from 1965. And another document that shows us an incident that the ACLU was concerned about. So if you look down at, let's see, I've marked this up for you. I'll give you a brief summary. This is a case where a local bookseller in the Minneapolis airport, hang on, I'm looking at what you guys are writing. The relationship between this interest and First Amendment rights and the increase in education through the post-war GI Bill, which gave, oh, that's a super interesting question. I love it. I've never thought about that. I mean, the GI Bill definitely brought new sectors of the American population into higher education. Might this have increased their sense of their rights under the First Amendment? Definitely. Might it have made them feel more powerful as consumers? Very possibly. Makes sense the feminine mystique had an audience waiting for its debut. That's interesting too. And I think if you look at like the post-war era in general, this is an era when consumerism is incredibly important. Consumerism is what helps the U.S. distinguish itself from the Soviet Union. What does U.S. capitalism do better than Soviet communism? Produce consumer stuff. Produce cars with fins and like 75 different colors of lipstick and wall-to-wall carpeting and lots of gadgets for your kitchen and your living room. So consumerism had become a really American thing. It was something capitalism was good at satisfying. And so I think it makes a lot of sense that this is a period when Americans are claiming rights as consumers at a time when consumerism is being really tied closely with what makes American freedoms, American values unique, especially vis-a-vis Soviet. So if you look at document number 12, here we've got the ACLU getting involved in this airport bookseller who's doesn't want to stock particular books because he's getting pressure. And the ACLU is worried because they say we're left with only the possibility of a reader's suit or a taxpayer suit, both of which may have standing problems which cannot be overcome. The bookseller in this case doesn't want to bring a lawsuit, as we've seen in the past. And so even by 65, booksellers are still reluctant to bring suits. ACLUs in local areas are still kind of worried about trying to bring a reader's suit. Is this going to work? But what happened is that readers themselves mobilized incredibly effectively. So not only did they form their own organizations, but they did things like write letters into the editor and bring complaints as prospective readers who should have the right to buy whatever books they want to buy. So what you find in the case of the Minneapolis airport bookseller is that the airport commission that had been pressuring it not to carry particular books backed down, and the airport bookseller started stocking those books. And it was all in response to readers who were complaining, writing letters to the editor, writing letters to the airport commission, and just claiming their rights as readers to have access to this material. So this had an impact on individuals and their sense of themselves and their own rights. It encouraged some individuals to form groups to mobilize and demand rights. It affected the ways that courts courts adjudicated the cases brought before them. And it also affected the way that the ACLU thought about how to recruit new members. And this is something I didn't give you documents on. I wasn't sure we'd get to it, but it's like super interesting, so we're going to talk about it. So Chicago ACLU, maybe some of you know this, maybe some of you don't, but Chicago is the home of the Playboy Enterprises. Chicago ACLU decided to take advantage of that, and they came up with a new membership recruitment strategy. So one thing they did is the Chicago ACLU thought, you know, readers of Playboy magazine probably feel like kind of embattled. I mean, Playboy was considered kind of on the edge, almost obscene, cheesecake stuff. You know, it's always kind of like right there on the line, pushing the boundaries. And the Chicago ACLU thought, you know, maybe if we can persuade Playboy readers that, one, they have rights as readers, and two, we'll protect those rights, and three, those rights are in danger, maybe we can get Playboy readers to join the ACLU. So they got together with Playboy and they said, hey, can we have your subscriber list and use it to recruit more members to the ACLU? And Playboy said, yeah, sure, here it is. So the ACLU took Playboy's subscriber list, sent its letters out. Playboy, why would Playboy agree to this? Let's just think about that. Why would Playboy agree to give its subscriber list to Chicago's ACLU? Why do you think they said, yeah, here it is? Knock yourself out. Possible clients. So Playboy thought ACLU, that they might become clients of the ACLUs and need ACLU protection. Good point, and they did often. ACLU defended Playboy regularly, beginning in the 60s. Yeah. Right, so it's not only the Playboy enterprise that realizes it might need ACLU support at some point, and it did, but also individual readers might feel a bit embattled. So what the ACLU did was it created a special letter to Playboy subscribers, and it framed its pitch to Playboy readers in some very interesting ways. And I know this is kind of teeny tiny, so I'm going to read you some select parts from this letter that was designed to attract people to the ACLU. The letter says, there are many people, you know the kind, who would do away with center spreads, etc. These are the same people who would censor magazines for other reasons, and movies and books, even though you have a right to read these, a right guaranteed by the Bill of Rights. So the ACLU sent out several versions of this letter, and one of the versions ends by pointing out that, and this is a quote, a reader who enjoys reading what you enjoy reading about should care enough to join the ACLU, the only organization that defends the rights of readers, writers, and publishers. What these membership building strategies did is they really strengthened the growing tendency among civil libertarians to associate freedom of speech with consumerism, and added a new dimension to that equation by treating consumers of cheesecake or consumers, readers of Playboy, as especially laudable individuals whose rights to read represented the vanguard of First Amendment jurisprudence. So this was, I think, a really important shift in the ACLU's strategy because it helped to equate it or to bring it even more close to a commercial enterprise, and to a commercial enterprise that was associated with kind of, you know, sexual liberalism. So by the middle of the 1960s, the much touted marketplace of ideas had taken on a character that would have been unrecognizable to the First Amendment's framers 2 centuries earlier, thanks in part to the efforts of civil libertarians who were riding the wave of post-war cultural and political trends that were embracing consumerism. The public arena was increasingly conceived of less as a forum for the exchange of ideas and information among citizens of a polity, and more as a marketplace of buyers and sellers, consumers and producers. It was no longer then a community with aggregate needs. This marketplace hosted individuals with singular claims to speak, to publish, and to access all that was spoken and published. Now, Andy, I need your advice here. I could go on and talk about some ways that other consumers tried to twist this strategy to their own ends, and that would take me about 5 minutes, or I can move to a conclusion and we can open it up for discussion. What do you think?
Well, we have about 20 minutes, and I think, so if you can do those 5 minutes and then conclude, if we're done by about 25 after the hour, I think we'll be good.
Awesome, okay. I'm gonna take a drink.
Besides, I know that you've got some really provocative images here that I want to.
You want to get to the vibra finger. I know. There it is.
I've never had vibra finger in a webinar. I've done 400 of these webinars. I've never had vibra finger.
Okay, guys, so hang on there. We're going to get to the vibra finger. Tell the kids to wait. Okay. So even as the ACLU was helping to fashion a new understanding of individual consumer rights under the First Amendment, they faced opponents who wanted to use consumer rights to achieve very different ends. So one of my arguments here is that consumerism could cut many ways, and the ACLU soon confronted consumer-driven legislation that was designed actually to frustrate their efforts to expand and diversify the media marketplace. So in 1963, so this was the year after Epstein's decision, and then again in 1967, so right in the middle of the 1960s, Congress held hearings on a series of bills that would allow consumers, in this case, the consumers were postal patrons or anyone who receives mail, that's you and me, all of us. The bills would allow consumers to identify material as obscene or obnoxious and demand to be removed from the sender's mailing list. The bill's supporters argued that mass mailings violated the privacy and sanctity of the home by bringing into it unsolicited advertisements from, say, an outfit called Eros or a homosexual group called the Mattachine Society, sadomasochistic material, or maybe a full-sized vibrating rubber finger for women. That would be the vibra finger. Friendly witnesses insisted that the sanctity and privacy of the home could be preserved only by postal legislation that allowed potential recipients of this material to reject any sexually oriented mailings. After all, if you think about it, many postal patrons in the 1960s received mail directly into their homes. You know those mail slots in the front door? Those were really common in the 1960s, less so today, but very common in the 60s. So many people received mail not just in their mailbox, but in their front hallway. So through a slot in the front door, mass mailings for these kinds of items cross the boundary between public and private. A graphic ad for, say, stripper's school book, or for scanty panties, or for vibra finger might drop through the mail slot and hit the entryway floor, awaiting the precocious mail snatching toddler, or more likely the homecoming of curious teens and hours later, angry parents. So throughout these congressional hearings in 1963 and 1967, supporters of the new legislation argued that without a new postal bill, consumers could not control what material entered their homes. Now, the ACLU was completely opposed to this. The ACLU said that consumers, if they wanted to, they could tear up unsolicited mail if they didn't like it. They could throw it away. When advocates of the legislation said, well, what about people's privacy? The ACLU replied, privacy isn't a constitutional right, but the right of freedom of speech and press is. So just a year before the ACLU would argue in 1964 in Griswold v. Connecticut that a constitutional right to privacy protected birth control use. It denied such a right in 1963 when opposing postal bills that would empower consumers to refuse sexually provocative mail. The mail debate actually raged on for years. Postal officials appealed to the Senate for legislation. They said, we're getting hundreds of thousands of complaints from people who are receiving unsolicited sexual mailings. And they said, we've got to have some kind of legislation to prevent this. They argued that when public sexual displays or when unwanted mail is thrust upon us, our privacy is invaded. Congress agreed. And Congress passed legislation that allowed people to reject mail that they deemed sexually provocative. And so this legislation is still in effect today. It's kind of a little obsolete given the age of the internet, but in fact, you can still request to have your name removed from a mailing list if you consider the mailing offensive in some way. ACLU said that this kind of legislation would be a disaster, that it would sexually sterilize American business and industry, and that it would be, here's a quote, a 20th century Mother Hubbard gowning. In fact, the ACLU was wrong. The law passed, still in effect. Others like it passed, and yet no return to the Victorianism that the ACLU predicted ensued. In fact, quite the opposite, thanks at least in part to the ACLU's ability to turn privacy and consumer rights to its broader agenda of diversifying and expanding rights of sexual expression. And so I would argue that the ACLU won the larger contest. Establishing in law, jurisprudence, and the broader culture a consumerist approach to the First Amendment raised public concerns about censorship, made people feel censorship personally and individually, heightened their sense of violation when they were denied access to particular media, and recast collective efforts to shape media content or limit distribution. And here I'm talking boycotts by church groups or boycotts by decency groups. It basically turned their efforts into what looked like censorship. So in the end, the postal laws that withstood the ACLU's assault wouldn't matter at all in a world of free-flowing video and internet pornography, material protected not only by the producers, but also by the consumer's right to free speech and privacy. And of course, by today, proclamations about the rights of readers have become very commonplace. So the larger point is that the Constitution is constantly changing, that it is how we interpret it, that individuals, as individuals and in groups, have an incredible impact on how the Constitution is interpreted and how it is experienced by individual citizens. And these episodes that we looked at together tonight are examples of how individuals by themselves and together completely transformed the ways that we think about our own rights and the ways that we experience the First Amendment. So what do you want to talk about? We've got 12 more minutes.
Yeah, 12 more minutes. That's really fantastic, LeAnn, to lay things out with using those examples as the lens to now pull us into the to a more contemporary time. And I'm going to invite everyone in our audience to register any question or any comments you might have in the chat box. But I'd actually like to start with one of my own, and that is, all the examples you gave are very familiar for me. I could remember or sort of recognize things. I'm not sure if my kids would know what Playboy magazine is, frankly. But
I don't think, didn't it recently go out of print? I feel like
it may well have, but for a certain generation that means something, the illusion means something, the allusion means something. Yep. But I guess my question is, you are working with students at Binghamton who are just a few years removed from many of the classrooms of the participants in the webinar tonight. How do you, and they've been brought up in this digital age, the digital landscape, where some of those touch points aren't quite as clear and the geography isn't quite as clear of consumerism. So how do your students respond to these kinds of conversations, and how do you get them to sort of grapple with these same First Amendment questions?
Yeah, I think the most important thing to do is to get students to think about the way they think as strange. I mean, I think most of us think, well, I think this way because this is how things are and this is natural and this is how it is. And it's really important, I think, to get students to realize that they exist in a particular time and place that has never been before, and they think about things and they experience things in a particular way because of this time and place. So the most important thing, I think, is to get them to realize that this is unique. Where they are today has never been before. And I think it's also important for us as educators to figure out where they are, what this unique time and place that they're inhabiting is. So I love the idea of, like I started this whole session out talking about a survey that I distributed. I mean, I was surprised by what I got back from students in 1997. Now in 2019, it's going to be even more like, whoa, really? So I think it's a really good idea to give students a chance to answer anonymously some questions about where they are today on these issues, how they think about them, how they experience them. And then after you figure out where they are, to help them see how where they are and how they think and how they feel is a product of this time and place, and how they've grown up and the era in which they've grown up, which is different than the era in which most of us grew up. That's a tricky thing because we don't know exactly where they are, and they certainly don't know where we are. And so it requires a lot of communication. And I think the best thing to employ as we're having these conversations is humor. We got to laugh about this stuff, or we'll be too uncomfortable to talk about it.
Yeah. Well, and maybe to put even a finer point on it, it seems like as you've discussed, as you've shared this tonight, that one of the inherent ingredients of consumerism is access. I thought it was interesting how several people very quickly pointed out that buying Tropic of Cancer in the 1950s or 60s meant having to go in and put it on the counter and look at the person in the eye and have them see you. And so there's no anonymity to consumerism back then. But of course today there is. And in fact, we can consume through the devices that we all have in our pockets, giving us cancer as we speak. So how does the notion of consumerism as it relates to the First Amendment evolved with ubiquitous access? Like we can get everything anytime.
That's super interesting because on the one hand, we think we can do everything anonymously, and on the other hand, we're freaking terrified that somebody's following us.
Yeah.
We're worried about that little camera on my computer. I'm sure somebody's watching me right now. And the algorithms
that actually.
Yep, the algorithms that track what we do and what we search for and what we buy. I mean, on the one hand, we feel like we're totally anonymous. On the other hand, we are absolutely certain that the Russians know everything we're doing, and so does the U.S. government. So this is a really odd time right now, and I don't know how it affects the ways that people actually behave, because it's true. You don't have to go look at a bookseller. You're, the guy who's in your, a member of your church to buy a skanky book.
Right.
But you're also kind of thinking if you access some porn site that your employer might know, or that somebody's collecting information on it that might come back to bite you when you're being, interviewed for a position on the Supreme Court. So it's a tricky time.
Yeah, there's no doubt about it. By the way, I've also in 400 webinars never had skanky involved, but thank you. I haven't heard that word before in our search term. So Suzanne has a question, and she sent it. Suzanne, I want to let you know that you're sending these to the presenters only rather than the group, which may be your intent. But I'd like to read her question out loud as our final and concluding question. It's a little bit long, but I think it's a really important one. Suzanne says, when the government was more restrictive on freedom of speech and reading, they limited our collective rights to maintain a moral balance as their responsibility to the country. Now that we have taken on more individual rights to decide what we can say and read, what is our individual or collective consumer responsibility to create an acceptable moral code for society? Or is this no longer the goal? Is this no longer desired?
Oh, that's such a good question. That's such a good question. And it's the kind of question that honestly keeps me up at night, because I feel like to the extent that we've individualized everything, we tend to act as if everyone behaves in their own individual interest and according to their own individual desires, somehow the greater good will be served. I don't personally believe that. um, that probably is not, I mean, American capitalism seems to function according to those rules, that the greater good is served if everyone acts in their own interest and according to their own desires. But I personally don't believe that, which doesn't mean I know what the answer is. But this all concerns me a great deal, which is why I spent so much time wallowing in it.
LeAnn, thank you for allowing us to wallow with you. We very much enjoyed tonight's session, and I appreciate you sharing your expertise. Thank you.
Thank you. If anybody wants to contact me like individually, my email is readily accessible online. Binghamton's website, type my name in, I pop up. I'd be happy to be in touch with anybody who wants to talk offline.
Great. And we're going to zip through a couple. So I want to thank everyone for joining us tonight. The National Humanities Center will continue to offer sessions and initiatives and programs like tonight's conversation that connects you expert educators with scholars and leaders in the fields for these compelling conversations. I'd encourage you to follow our Facebook and our Twitter accounts so you can see upcoming announcements and have access to the different kinds of registrations for those. And I would also hope that you will join us for our next webinar session, which is scheduled for September 17th. We'll be working with Bill Deverell from the University of Southern California on California and the history of North America. I know we often have many Los Angeles and Southern California teachers. This will be one that's not only appropriate for you, but I think for those of us not on the West Coast, allow us to position California much more directly in a lot of the cultural history that we teach. Before you go tonight, I am going to do a little bit of an experiment, and that is I'm going to launch the post-webinar evaluation. And so oftentimes when I close the room, and you get a survey that you're asked to fill out, but we really do value your answers and your participation. So I'm going to launch this now, and I'm going to leave the room open for probably 10 or 15 minutes to give you a chance to complete it. Again, please feel free to reach out anytime with suggestions and feedback. Thank you again, everyone. Please have a great day at school tomorrow, and hopefully we'll see you again in the National Humanities Center Humanities in Class webinar series. Good night.